The next matter to come before the court this morning is John Walls versus Joseph Testa et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get going, I'm keeping the clock this morning to keep you apprised of the passage of time. The court has read the briefs and we're ready to proceed when you are.
Thank you, Your Honors. May it please the court, I would like to reserve 5 minutes of my time for potential rebuttal. As the court is aware from reviewing the briefs in this matter primarily deals with evaluation of personal property.
And counsel, I probably messed this up because I started with the spiel about rebuttal, but it's usually good practice to let the court know who you are. We may learn. Thank you.
Attorney Gino Polito on behalf of the appellant and John Walls. So the case deals with evaluation of real estate. In the instant case, we believe that the decision of the Board of Tax Appeals is incorrect and reversible as unlawful. And unreasonably determined the value at $303,000. The case deals with a parcel of property that is unique. There are only two in Lorain County, and the two sold in 2009 for approximately the same prices. In this matter, falls under the prior statutes as it relates to evaluation. And the prior statute under IRS Code Section 571303 mandated at that time that the auditor shall consider the sales price of a parcel, provided that it was reasonable in time. The hearing on this matter occurred in 2013. There was no bright line rule at that time as to what reasonable amount of time meant. In this case, we had a 3-year period. At the hearing with the Board of Revision, however, Mr. Walls provided testimony by a broker in this area who provided a report to the Board of Revision at the time of the hearing, as well as proper testimony at that time that supported that the value of such a property approximately 3 years later was still $90,000 because of its uniqueness and ability to market for any additional amounts. Testimony was further provided by Mr. Walls as to that there wasn't a change in marketability in Lorain County, and that the attempts to lease the premises resulted in continuous losses on this property.
So as it relates to Mr. Wagner, his testimony was not excluded, correct? It just was not given credit.
That is correct.
Okay, thank you.
So the Board of Revision came out and confirmed that their value was proper, and Mr. Walls appealed. During a time period between the notice of appeal and the ultimate hearing on this matter before the Board of Tax Appeals, the Supreme Court came out with a somewhat of a broad line test with regard to properties that may have sold within 2 years and prior to the reassessment, the 6-year reassessment conducted by counties. And basically, in that decision, what the court found is that there would be no presumption with regards to value if it was outside the parameter of the 2 years and there was an intervening appraisal done. But nevertheless, the proponent could come forward with additional evidence that would show that the market conditions or character of the property have not significantly changed between the sales date and the lien date, which in this case we expect to submit that Mr. Walls successfully did at the Board of Revision, and further testified at the Board of Tax Appeals as it related to market conditions and as it related to attempts to rent and profit from the property, and it just wasn't successful. The record has his financial information for all the years that we provided that show significant losses in each of 4 years.
Aside from the losses, which I did get the impression that was contested by the state, I just didn't see that as being an issue. But what are we to make of the testimony regarding the improvements that were made to the property and there was some suggestion that it was rented out to family members and friends. In other words, there was not much, there were not many resources that were invested in advertising it to the broader community. What do
Yes,
you
ma'am.
make of that?
The repairs that were made were primarily cosmetic. So there was graffiti on the outside of the building, it was repainted, some landscaping I think was done. The pool area, which was non-functional, was filled in, and in fact was converted into an indoor soccer arena.
That's not do you consider that cosmetic?
Well, filling in of the pool and putting the tarp over it is not a major expenditure, but the question then becomes, what is the market for such an enterprise? And there isn't. There was a complex nearby in Lorain County that shut down that had soccer facilities. Just was not sustainable. In this particular property, in the first year that Mr. Walls acquired it, in fact, the school board rented space for projects that it needed to do. But after the first year, it abandoned the property as well. It is a nice one. There are complexes that are much more modern, with much better facilities, with air conditioning, heating, that are sought out versus this particular property. Mr. Walls indicated that he didn't market it because he didn't feel that he could get anybody to rent it. He did do word of mouth and footwork in order to get people to get there. That, in fact, some were family members, but others were churches and other organizations. I believe one was martial arts or some sort of facility. But it didn't bring in any significant amount of money, and he is not opposed to renting it to the general population if, in fact, somebody needed the space. I think at some point in time, he had to think that putting good money into bad money with regard to trying to get people in there just wasn't a smart business decision. Further, in the history of this particular property, and we alluded to it in the brief, the Board of Revision had previously made a decision that, in fact, this property was worth $90,000. That was an appeal that Mr. Walls had brought himself a couple of years prior and was ultimately dismissed by the Board of Tax Appeals on a jurisdictional reason, under the guise that the complaint that was filed with the Board of Revisions was filed late. And so that decision didn't go into effect because the school board was successful in challenging jurisdiction and the Board of Tax Appeals reversed it. But the other parcel, the only other parcel that is close to this is the second parcel that was owned by the YMCA. And that too went for, I think, the original sales price was around $86,000. And that too has not been able to get any traction with regard to marketing and making it into a piece of property that's significantly more valuable. Consequently, it is what it is. It's a one-use facility that is not easily marketable, and that is confirmed by Mr. Wagner's opinion and testimony that as a result of the single-use purpose, property, even though it had improvements made to it, still added value for sale of $90,000.
Why is it that you think that Mr. Wagner's report and opinion as to value should be given the same credit as the more qualified appraisal, licensed appraiser?
The case law in the statute does indicate that a broker is in fact a qualified expert to give opinion in these matters. Mr. Wagner is a broker and the owner of Greenbridge. As a result, he has the qualifications for their opinion.
But as best I can understand from the briefs, he didn't do all of the market analysis and other investigation techniques that a licensed appraiser would have done. Am I misunderstanding the record?
No, ma'am, I don't think you are. His appraisal is not to the extent of a certified appraiser. Take a multitude of different factors, including the cost approach, or the income approach, or the value of real estate. But that doesn't disqualify his opinion as to whether he can sell that piece of property. He is deemed to be an expert for those purposes. In this case, as a result of the negative cash flow for a number of years, I don't believe that even a certain appraiser could come to the conclusion that this piece of property at an income approach would be worth anything more than $90,000. And certainly with regard to the appraisal that the county has, it's a mass appraisal.
What do you mean a mass appraisal?
They go out and they try to look for comparables and they use their best guess. As appraiser doesn't use an income approach, as far as I'm aware, either. And again, in this case, there was only 2 properties that needed to be repaired. And for him to come up with a value of $330,000, obviously, he has to take a look at the other parcel. Because even the county's records indicate that the other parcels was being appraised by the county. The prior parcels was traded within that period of time for significantly less than $230,000.
And Council, you're just now reaching into your 5 minutes for rebuttal time.
Thank you. I will, unless there's questions at this time, I will reserve 2 minutes.
Good morning, Mayor. Please the court. I'm Jack Kilroy, attorney for the Lorain County Auditor and Board of Revision. I'll be taking about 10 minutes and reserve the balance to my colleague Tom Conser, representing the Lorain Board of Education. And please excuse me if I need to sip water during the hearing of a medical condition that affects my throat. I have a very dry mouth. But the party seeking change at either the Board of Revision or the Board of Tax Appeals, in this case John Walls, has the burden to prove by competent and probative evidence that the value they seek is correct. And the Board of Revision and the Board of Tax Appeals each conducted evidentiary hearings, and both parties determined that the evidence was insufficient to justify a change from the auditor's value. So after 2 evidentiary hearings, it's not appropriate for the appellate to ask this court to take another look at evidence and make a different finding of fact. So the appellant, John Walls, must show that the Board of Tax Appeals' decision was unlawful or arbitrary, amounting to an abuse of discretion. So what did the Board of Tax Appeals have to hang their hat on? Well, John Walls attempted to meet his burden of proof by presenting evidence that the most recent sale of the subject property was both recent and arm's length. But the record supports the conclusion of the BTA. The sale evidence is insufficient to support the claim of adjustment of value, and that this sale should not be relied upon because the record shows the property was substantially changed since the time of the sale. The
And
transcription.
excuse me, by that you mean the substantial changes, the putting in of a floor? Instead
By
of-
remodeling, including transforming the pool into a river soccer court, and including spending $70,000 on a property that they bought for $90,000. So the investment went from $90,000 to $160,000. I think that would be a monetary substantial change, as well as the use of the property changed and the nature of the property changed. You know, the swimming pool changed into a soccer arena.
But it does strike me that a change of that nature, I wonder how we reach the higher figure of $300,000+. If you add the repairs to the price, you're only just about halfway there. So I'm having a little trouble understanding the appraisal in this case at $300,000.
Well, for that approach to value, you'd have to start with a good sale, valid sale, as the base cost, and you'd have to also adjust for not just the dollar for dollar investment, but for the value added. So I don't think you can get value by adding 90,000 to 70,000. I don't think there's any method of valuation that would support that.
So does that mean that the $90,000 sale figure was artificially low, or does that mean that the sale was so far away in time? I think it was 3 years or so, maybe it was longer than that, that given that it does not meet the recency requirement?
Well, the sale doesn't meet the recency requirements for January 1st, 2012. It's nearly 3 years old. It was January of 2009. The evaluation date's January of 2012. The Akron Schools case said that there's no presumption of recency when the sale is over 24 months and it crosses over a reappraisal date, which is the case in this particular instance. Secondly, the sale doesn't meet the definition of arm's length because the record shows that it was a deal made between the auctioneer for the property and Mr. Walls after the auction didn't get the minimum bid. And so the property wasn't exposed to the market at the time of the sale. And part of the definition of an arm's length sale set forth by the Supreme Court is that the property needs to be exposed to the market for a reasonable period of time. This property was not exposed to the market at the time of the sale. Secondly, it was a forced sale. The property was distressed. The statute covering sales specifically says you shouldn't use an auction sale, but even with this, that was pulled from the auction and a side deal was made with Mr. Walls. So it wasn't really an arm's length sale to start with, plus the problem at the time. So, the BTA certainly could have looked to those factors and did, but it's in the record. There's ample reasons for the BTA to disregard that sale. Recency, substantial change, and not arm's length. Additionally, the record shows that the issue of the sale was adjudicated. There were board of revision cases in 2009 and 2000 for tax years 2009 and 2010, where in 2010 the board didn't find that the sale was valid. And this is the third time it's come up in a different tax year. But the value of property in the market changes with each tax year. So a different valuation date means that you have to look at different things. But the Akron case, as Mr. Polito was trying to point out, allows, if there is a sale that's more than 2 years old, to show that nevertheless it's a good sale. That they can't do this by Mr. Wagner's report. There's no evidence in the record to support Mr. Wagner's qualifications to express an opinion. He didn't put forward whatever qualifications he might have. He might be the best qualified person in the world, but we don't know that from the record. The report itself is an undated, unsigned letter bearing Wagner's name that was presented to the Board of Revision. And it's not an appraisal report. And even if it was considered an appraisal report, it doesn't comport with the standards of the Uniform Standards of Professional Appraisal Practice, commonly known as USPAP, which is incorporated by reference into the Ohio Revised Code. There's no demonstration that any of the accepted methods were used in his analysis. A sales comparison approach would identify the comparable properties and the adjustments that are made. An income capitalization approach would identify the income expenses and the capitalization rate and to come up with a conclusion. A cost approach would show the cost of the land, cost of the improvements, and a depreciation factor. None of that's done. When we learn long division, in school, our teacher says, show us the work. And they don't show us the work. Any qualified appraiser, whether they're licensed and certified or whether they're not, would show you the work. And in this case, they don't show you the work. They don't even give you a validation date on that report.
So as I understand it, if Mr. Wagner had, although he's not a licensed appraiser, had he shown the work in substance that a licensed appraiser would have done, you would not have rejected his report?
Well, it could be. I mean, the Board of Tax Appeals, I don't know of any case where they've accepted a broker's opinion. I know of many, many cases where they've rejected a broker's opinion. But theoretically, the case law is theoretically a broker could present a good appraisal if they show the qualifications to make that, express that opinion, and if they show their work.
And you agree that the court did not ignore the testimony or the report. It just didn't give substantial credit.
I believe that the Board of Tax Appeals found that the appraisal was insufficient to justify a change in value. It wasn't well documented enough. And finally, Mr. Wagner, an appraiser should be a disinterested party. Mr. Wagner wasn't disinterested. He was the man that brokered the sale. If he comes up with a higher value, his client that he sold the property for would say, well, why didn't you sell it for what you said it's worth? Comes with a lower value, Mr. Wells is going to say you charged me too much. So he had to come up with the number he sold it for. He was not a disinterested party. So in conclusion, the sale in 2009 does not present evidence of value on January 1st, 2012. One-page letter from John Wagner does not meet any appraisal standard. There's no other evidence really in the record. So the Board of Tax Appeals had plenty to hang their hat on when they made the finding of fact that there was insufficient evidence. And it's not whether this court might weigh that evidence differently. It is whether the Board of Tax Appeals had enough facts to make a rational decision, and they did. I have nothing further.
May it please the Court, I'm Thomas A. Conser, counsel for the Board of Education of the Lorain City School District. I think Mr. Kilroy adequately addressed the vast majority of the issues in this appeal and did show that the standard here is that this court, to overturn the Board of Tax Appeals, must find that the Board of Tax Appeals abused its discretion. And there has been no showing that there's been an abuse of discretion in this case. In this case, the county auditor set the value of the property at $303,500 for 2012. That was after a reappraisal year. So the county auditor was aware of the 2009 sale that was 3 years old, and it did a reappraisal of all the property in the county. And when the auditor reappraises, the auditor does not only a sales comparison approach, but also does an income approach to value. And the auditor, being aware of that sale, concluded that the sale was not a valid indicator of value and set the value at $303,500. The auditor...
What's in the record to support that? And I think Judge Whitmore asked that. What are we going to find in the record to support that particular figure?
That would be in the county record card, which I believe is Exhibit C to the statutory transcript. It shows, it's a property record card in which the county auditor makes indications of what has happened in the past with the property and whether improvements have been made. And like in this case, it will show that in 2009, Mr. Walls appealed the value, which at that time was over $1 million. But he had filed late requesting a change, so no one had authority to change the value. Then in 2010, the auditor dropped the value down to $610,900. Mr. Walls again appealed that decision, lost at the Board of Revision, appealed it to the BTA, and just didn't show up at the BTA hearing. So the BTA said, you haven't presented evidence to show that the auditor's value was wrong. And then when the auditor did the reappraisal in 2012, reviewed the property again, reviewed the sale, reviewed the improvements that were made. I mean, Mr. Walls, invested the sale price into the property and improvements and converted a pool, which frequently is considered a liability because of the injuries that can occur, into an indoor soccer field and a baseball practice area, which could substantially improve the value of the property. The auditor valued it at $303,000. And here again, I think the property owner has shown no evidence that that value is wrong. The sale is 3 years old. The Supreme Court has said, when you have a sale that's more than 2 years old and the auditor reappraises the property after that sale with knowledge of the sale, it's up to the property owner to prove that that sale is indicative of value. In order to do that, the property owner has to show two things. There's been no change in the building. Property owner didn't show that here. In fact, the property owner testified that there was substantial changes to the building. And the property owner has to show there's been no change in the market. And there was no testimony that there was no change in the market in this case.
So is the record reflect that, is it going to show us that the reappraisal in 2012 reappraised the building from its prior tax valuation of $600,000 to a tax valuation of $303,000?
Yes, that should be shown on the property record card.
Thank you.
And finally, with Mr. Wagner's, I think the court is correct. The BTA and the Board of Revision considered his testimony, but didn't find it credible because he was testifying that in 2012, the property was worth the same as it was in 2009 when it was sold, even though the property owner invested $70,000, $80,000 into the property. And Mr. Wagner was testifying that made no change to the property. And he testified to that without even testifying that he had actually viewed the changes and considered how that would affect the selling price of the property. And for the reasons that Mr. Kilroy said, that there was no evidence presented by Mr. Wagner as to how he arrived at his value, the Board of Revision and the BTA were both correct in finding, or certainly had a basis in finding, that his value was not credible, and therefore the property owner presented no credible evidence to justify a decrease in value. And that's what the BTA found. They said there was no evidence shown that the auditor's value was wrong, therefore it affirmed the auditor's value.
If the evidence had been presented that the efforts were made to use the building as indoor soccer and whatever, if evidence had come in that the building community did not support that as a basis of income for the property, would the decision of the board have been different?
Well, I can't tell you what the decision of the board would be, but I will tell you that that should not affect the decision of the board, because the value of the property is determined by its ability to generate income. And the fact that Mr. Walls was not able to generate income from this property could be a function of the market, or it could be a function of his mismanagement of the building. And you'd have to know that before you could determine how.
And none of that information was presented.
No, in fact, I think you could imply that it was mismanagement, because I think in the financial statements, Mr. Walls said he spent $13 over 3 years advertising the building for tenants. That would indicate to me mismanagement if you're trying to rent a property. You spend $13 in trying to get tenants for it. He also testified that he tended to rent it only to friends and acquaintances because he wasn't really marketing it as a rental property. And that's why he couldn't rent it.
And counsel, regretfully need to inform you for the end of your allotted time. Thank you.
Thank you.
That Mr. Walls would rent only to families and friends, obviously, is contradicted by the fact that the school board was a tenant of his for a year. He had no reservations on renting to anyone that was interested in approaching him and renting the properties. A couple of misstatements made by the auditor in this case. One was that in 2010, when the first complaint was filed, there was a determination that the value of $90,000 was not appropriate because it wasn't at the sale. That is not at all what happened. In fact, the Board of Revisions accepted the $90,000 as being the value of the property. When Mr. Walls responded and went to the Board of Tax Appeals, his case was in fact reversed for lack of jurisdiction by the board to make that decision.
But is any of that in the record?
I believe there was testimony to that in the record by Mr. Walls. That's correct. With regard to whether it was a valid sale, again, the testimony is very, very clear. Mr. Walls did provide it. There might have been at some time an auction. It did sell at auction. The entity that held it, which is not at all related to Mr. Walls, doesn't know Mr. Walls, doesn't have any special business dealings with Mr. Walls, all on the record, then decided to hire a broker to market the property. Mr. Walls was interested in the Elyria YMCA and had made some overtures and put bids in to buy Elyria. That was sold to somebody else. When that transpired, Mr. Wagner had also the charge of selling the Lorain property and approached Mr. Walls with regard to buying the Lorain property. And the deal was consummated with the Lorain property. So this property was offered to the public for sale. Two individuals were interested. One bought the Elyria and Mr. Walls bought the Lorain. It didn't have value. It is a monstrosity. It is a large, old building that requires a lot of work, a lot of heat, and a lot of expense associated with it. It just isn't worth what the county had initially continued to appraise at $1 million, then at $600,000, and then at $300,000 and some thousand dollars, as the case here. Mr. Wagner's qualification as a broker are outlined in his report, and he testified to that at the Board of Revision. He has 11 years' experience. He sold these types of commercial properties. There were only 2 properties in the county for which he could discern what the value would be, both of which, in fact, he did sell. He had actual personal knowledge of the business and the market. And he knew that he couldn't sell these properties for more than they had been sold previously. And he testified to that at the hearing where he was subject to cross-examination of the Board of Revision.
There's been some discussion about the report being unsigned and undated. Was there any objection to its consideration?
There wasn't any objection. He submitted it in person to the Board of Revision, and he was there to testify as to particulars in his report, all of which could have been accomplished. And in fact, he was questioned at the Board of Revisions with regard to his qualifications. And he also testified prior to 2010 with regard to the value which the Board of Revision at that time accepted. So for the foregoing reasons, I believe that Mr. Walls has met his burden, which, and again, during the pendency of the appeal, the Supreme Court came out with Akron City versus Summit County Board of Education, County Board of Revision, and the standard there is, if it is over 2 years and if it is an intervening assessment period, that it is a proponent that needs to show that the market conditions haven't changed. I think that clearly has been established. And then that the character of the property hasn't changed. Not that improvements were made or not made, but what can this property be used for? And it is an old YMCA building. It has no other use other than for some indoor sporting activity. The character hasn't changed in the least. And according to those facets, Mr. Wagner, I think, appropriately valued the property and rendered a good value. This property has no more value than when it was purchased in 2009. For those reasons, I believe that this court should reverse the Board of Tax Appeals and enter judgment that the value of is $90,000. Thank you.
Thank you, everyone, for your presentations this morning. Court will take the matter under advisement, issue a written decision, which will be mailed to all sides as well as posted on our website, the Ohio Supreme Court website, which you can link through our website. Thank you.
Thank you.